Rise. Minnesota Workers' Compensation Board of Appeals is now in session. The Honorable Deborah K. Sutcliffe presiding.
You may be seated. Good afternoon. My name is Deb Sutcliffe. I'm a judge in Workers' Compensation Board of Appeals. I'm joined today. Can you hear me?
Microphones are off for the owl, so we're not using the microphones, so we need to project it.
Thank you. All right. Thank you for that clarification. All right, we are here today on two matters. But before that, I'd like to introduce who will be joining me on panel today. To my right is Chief Judge Millen. To my left is Judge Christensen. We will first hear the issue of the matter of Engblom versus Gateway Foods. It's work comp file WC 236506. Looks like we have Ms. Balmer here and Mr. Cordes. Right. Ms. Balmer, you know that you have 15 minutes to present your argument. If you'd like to reserve some time for rebuttal, let us know. We will start with you. Thank you.
All right, may it please the court. My name is Stephanie Balmer. I represent the employee, Craig Engblom. As the court is well aware, we are here on an appeal from findings in order of a compensation judge regarding a number of claimed medical expenses. And these medical expenses arise out of a May 1989 admitted lower back injury. I am not going to go through Mr. Engblom's medical treatment history, as the record is significant in this case, and I would like to highlight a couple of points shortly.
I'm going to interrupt you first because you gave me the segue. Here, we're not going to go through play-by-play of medical history, but I mean, really the question is, and we've had discussions on this, on epidural steroid injections and radiofrequency ablations, right? There's no dispute that the treatment is outside the treatment parameters, correct?
That is what the compensation judge's findings and orders say. And I understand through counsel's responsive brief that the subsequent case, Solinger, has been raised. Is that where the court is going here, Your Honor?
Well, I guess I'm just going to get to the heart of the matter.
Yes.
The question that you posed in the brief was whether it would be appropriate departure under the Minnesota rule, or that it's a rare case exception pursuant to Jack and the cases that follow. So I was going back and trying to put together what you both agree on. You agree that neither the statute nor the rule defines the term progressively.
That is correct.
Okay. And you don't agree that the dispute moves right into the question of whether or not the treatment is outside the treatment parameters and should be awarded as a rare case exception for an appropriate departure under Minnesota Rule 5221, 60507.
I'm not clear on whether we're in agreement on that, but I'd be happy to explain our position on that, Your Honor.
Oh, that's great. That is good to know. And then I'm going to be asking you both of you some questions. How do we measure progression? Should temporary improvement be considered? Is the progression improving? When in fact progression could be a disease that's going to its ultimate demise, such as other conditions like ALS.
Yes.
So I'm not quite sure where we're moving in terms of a discussion on the linear part. But I am looking for an analysis on what the plain language of the statute and rule mean to this end, and how we understand what the compensation judge should have done or didn't do or did do in his analysis of whether or not this case poses a rare exception or fits into a departure under the rule.
Yes, Your Honor.
That's a lot, and I apologize. It's maybe
No, I appreciate it, Jerry. I got no issues. That's
Yeah.
what we're here for.
That gives me an understanding for me, the outline that I need to look.
Thank you, Your Honor. I will address those points. So first of all, I'll address this issue of what is progressive within the meaning of the Workers' Compensation Act. As the court's already pointed out, it is not defined in the statute. My position is that the treatment that we're here about today is treatment that is meant to cure and relieve from the effects of the admitted injury. My position is that the treatment has been progressive and that the dispute has to do with what points begin and end on that progression. In other words, where is this linear visual, we'll call it for today's purposes. Arguably, all treatment is temporary with some exceptions. Back surgery can be temporary. Physical therapy can be temporary. Medications are temporary until you take your next dose. And so if we are going to embrace a finding that says treatment that is, quote, only temporary, end quote, then I think that is a slippery slope. It has not been how the courts or frankly any other entity in this arena have analyzed medical care up until relatively recently with these very expensive injections and radiofrequency neurons. And so I don't think because the medical care is expensive that should change our understanding of the term. Mr. Engblom's treatment provided him with temporary relief, and then he came back when the effects of that treatment subsided. He did have varying degrees of relief. There were some treatments that provided him with no relief. Sometimes he had worsened symptoms. But our position is that in all, the treatment in dispute provided him with relief and allowed him to do the types of functioning that the statute is meant to allow him to do, such as work a part-time job, perform his other treatments, such as his home exercise program, interact with his loved ones, and so on. And so that is our position with respect to this term progressive. I do think it varies case to case. As this entire case is, it's a fact-specific case, and what is progressive in one situation may not be progressive in another. But for purposes of this claim, our position is that the record shows that there was progressive relief.
Ms. Palmer, I'm sorry. Ms. Palmer.
Yes, Your Honor.
Right. This the segue here is the fact. Is this a substantial evidence case, or is this a case in which we have to analyze the law? Under the Darchers, Jones versus Darchers case, the Supreme Court actually looked at a very similar situation applying its treatment parameters. And their standard review in that case was a law. They reviewed it on a de novo basis. Can we also review this case on a de novo basis?
I believe it's a mixed situation, Your Honor. I believe I concur with the court in terms of, well, the Darchers court in terms of it being a matter of law, in terms of applying the law to the facts. But because the facts differ case to case, I think it's a mixed issue. I did actually make some notes here before we began. Our position is that the legal issues for today involve this matter of temporary versus progressive, as I've discussed already. Application of that legal point to the facts would be a question of fact, and our position is that that is also unsupported by the record. So I understand that would be a Hagen-Mueller issue, and I take that head on and believe that the record does not support the compensation judge's findings on that issue.
Did the judge have analyzed this case in terms of work activity, daily living activities, as opposed to a linear analysis that's temporary and therefore it's not fitting into the juvenile exception or the rule for departure?
I agree that I believe that the judge should have analyzed the case in terms of Mr. Engblom's everyday functioning, including his work activities. I believe that the compensation judge feels he did in terms of his memorandum explaining his findings. one of his findings was that the record showed that there were no changes in Mr. Engblom's functional status. And that is one of the primary reasons why we're here today. To conclude that the changes were not enough is one thing, but that's not what the compensation judge found. He found that the record did not show any changes in Mr. Engblom's functional status. That is simply untrue. And I recited a number of examples in my briefs. Our position is that not only did the record show these functional changes, but that they were substantial and qualified for the departure in our case exception.
So if the judge had measured the progression on a different timetable as opposed to temporary versus permanent, the opposite, or had measured in work activity or any activities within a given period of the treatments or within a given period of a 12-month cycle of a year, when the analysis draw a different conclusion of whether or not it meant the departure of the rule or their case exception?
I think that can be true, Your Honor. I agree that a lot of this analysis depends on the starting and ending points. And I'm sure that doesn't help the court in terms of what am I asking for here today. I'm not asking for the law to be changed. I'm asking for the court to clarify that the statute requires treatment to be paid for when it cures and relieves from the effects of an injury.
Ms. Vollmer, in the Johnson versus Dartrix case, Supreme Court did, and they concluded that we need to look at the treatment factors first, not the statute, which appears to be contradictory to everything we've learned, right? Which is the statute comes first, it's primary, and then the rules follow. That's not what they did in that case. But in that case, they talked about the opioids that the employee was taking. And also in the most recent case, the Cylinder case, that's also a case. Right? This is not an opiate case. This is a very limited injection case, bends, the epidural steroid injections. It warrants like maybe 3 lines in the treatment parameters, whereas the opioid treatment has 5 pages. So clearly, there's been a emphasis on the opioid treatment. Very much, very serious and a national crisis, right? Do you think that makes a difference here as far as our review of the statute and rules? Does this warrant a lighter touch? This case warrant a lighter touch than the way the Supreme Court addressed treatment parameters in the Johnson versus Dartrix case?
Your Honor, I agree that, well, I feel that there were some public policy elements, not only in the Dartrix case, but in a number of compensation judges' decisions, findings and orders over the last several years. And I'm not being asked to talk about whether that's right or wrong, but I'm being asked to advise the court of our position as to whether the courts should apply the same degree of attention, I suppose, to this type of treatment. No, I think it's different. I think it does deserve a lighter touch, as you put it. Medical care is heavily scrutinized in the workers' comp system, as it should be. We have several different agencies participating in what should and should not be covered. And we have many layers of analysis in that regard. And in the Dartrix case, the court was being asked to deliver, I feel, some final positions on the compensability of narcotics in a workers' comp setting. This is still a factually distinctive situation, I believe. Because in Mr. Engblom's case, he weaned himself off of narcotics. He's been told that a spinal cord stimulator might help, but then actually not. He's been told a very extensive surgery might help. He doesn't want the extensive surgery. He doesn't want the narcotics. He doesn't want the spinal cord stimulator. This is the only treatment that has been helping, and this is the only treatment that he's been asking for. There aren't any other options. And so
Taxes,
it does.
the effectiveness of it.
That's true.
There's no progressive linear march moving forward that he's getting better and better and better. But where in the statute of the rule your clients go to when in fact it's keeping them afloat?
That is what
Opposed to swimming to shore.
That is what Mr. Engblom asked me. He said, I don't understand why short-term relief doesn't count. And I'm arguing that it should count. It does count under the rules and the statute.
Where would you point us to take a look at the rule section that does allow for that interpretation?
Progressive can start where he is unable to work. He's unable to move around his house, do his chores, go out and pick up groceries. And it can end where he's doing all of those things. If the treatment wasn't helping him, we wouldn't be here.
Ms. Palmer, compensation judge relied or actually found Dr. Gurin's opinion persuasive and then adopted that when he made the findings of our. In looking at Dr. Gurin's IME report, it appears that that report was written 6 years ago, 6 or 7 years ago, right?
I believe that's right, Your Honor.
And that was actually for your client weaned himself off narcotic meds. And so the number of pages in the report is like 100 pages long. A number of those refer to his opioid use. And I'm wondering if, in fact, now that he has weaned himself off narcotics, that changes the whole equation here. And if it does, did Dr. Gurin have the necessary facts today that you didn't have 6 years ago when he was still, on heavy narcotics?
I would be speculating to say whether if Dr. Gurin had the facts before us today, she would have changed her opinion. I will speculate. I would say that she would have the same opinion based on what she found. She disagreed with every single one of Mr. Engblom's doctors, as well as Dr. Buin, the other doctor hired by the employer, in terms of objective findings, diagnoses, treatment. Her opinion is extreme. And the employer insurer paid for treatment after that opinion in contradiction to her opinions. And so I would intimate that the employer insurer is aware of its extremity or extremeness. Does that answer your question, Erin?
It does. And I'll tell you, there was a phrase that was used in one of the five records, and it was from Dr. Hal. He was a treater back in 2016, before Dr. French. He said, to deny this man a viable means of pain relief for now and in the future is cruel. So this man was under a lot of pain, and this doctor said it would be cruel to deny that relief. And I think that was really disturbing and actually very powerful. Because now we see the findings of order that his pain relief has been denied. And is that cool? And if so, or if not, what does he do now? Where does he go? How does he find relief?
I don't know if it's cruel, Your Honor, because that implies that the decision makers are applying their own moral code to the situation, and that would require a lot of speculation.
But this is a doctor's.
Oh, yeah, yes. I don't know that Dr. Heyer can opine on morality or intent, but I think he's a pain doctor. And he clearly believed that Mr. Engblom was suffering from the extent and nature of symptoms that he was reporting. And so now that Mr. Engblom has been cut off, he is trying to get his personal or private insurer to pay. But as the court is probably aware, sometimes when a judge makes a finding that treatment is unreasonable and unnecessary, that can cause a global denial from all insurers. So that is what is happening with Mr.
So I had to follow up on that. We place the burden of financial back into the private industry because workers' comp doesn't cover him.
That is, yes.
Public policy
Yes, if workers, if there's a workers' comp decision finding that medical care is not compensable for any reason, then generally the injured worker would take that to his or her personal or private insurer, and they would bear the cost. That is how it is usually done. The problem with that is that then the injured worker bears co-pays, deductibles, sometimes higher premiums, and then sometimes, depending on the details of the denial from the work comp entity, there's no coverage in the personal or private arena either.
I have one final question. Maybe, it's neither fair nor reasonable or causally related. We go back to the statute on his treatment of the epidurals and the inflammation. So, and the reason it's not fair and reasonable is because it's not in the code to begin with, and it's not a departure. Is that the only thing that makes it unreasonable and unnecessary?
I'm not clear on your question, Your Honor. Are you asking whether that was the judge's decision?
I'm asking based on the findings of the CJ, the compensation judge, and he made that finding that it was not reasonable and necessary.
Right.
Why? Because it's not in statute or the rule itself and doesn't meet the requirements, as opposed to a continuation of treatment that continues to allow somebody to not self-medicate and move to a system of daily living and work activities.
Yes, the compensation judge found that the requested treatment was unreasonable and unnecessary because it did not provide progressive relief. And that was the underlying basis for the denial of the exception and departure findings as well. And so, as I mentioned earlier, our concern is that that is a dangerous finding that could have far-reaching circumstances in terms of the temporary nature of a lot of medical treatment.
Ms. Palmer, you are over time, but we needed to ask these questions. Judge Christensen, did you have any questions at all?
I have one question. Parameters talk about either progressive improvement or objectively improving in terms of the RFNs and steroid injections that he's had since the early 2000s. But that care, in contrary to progressive improvement, they haven't progressively worsened his condition. The care and treatment was received either through the ESIs or the ablations, and instead it seems like he's continuing to work, and on a holistic basis, it's not worsened. It's, as you said earlier, maintain the status quo, at least some semblance of life that he has working.
I would agree with that, Your Honor. I think on average, he has improved. If you compare Mr. Engblom from before when he started receiving the injections and the rhizotomies, he was very low functioning. I think the records will reflect that. If you average out his state from when he began those treatments through relatively recently, he has very much improved. As you mentioned, he found a part-time job. This is a man who needs to work. It is part of his identity. And so that has been contributory in a number of ways. It's kept him moving. It's kept him emotionally more stable. And so that is, I think, the best evidence of the effects of the treatment. And certainly they have not worsened. Yes, that answers the question. Anything further?
Thank you, sir.
Thank you, Your Honor.
Support.
Good afternoon, and may it please the court. I wanted to actually start my argument here talking about the standard of review, because I think that is a critical issue in front of you before we get to everything else and talking about the parameters. And the reason I want to do that is because this court and the Supreme Court have made it very clear that when you're dealing with the treatment parameters, when you're dealing with the departure, the standard should generally be on the Hengemulin standard here, and that the question of whether treatment is reasonable and necessary is a question of fact for the compensation judge and shouldn't be handled unless not supported by substantial evidence and is clearly erroneous. And in Darchuk and Martin and Kozlak, that was extended to the rare case exception as well. And so I think that the application of progressively improving and the other language of the departure statute is not even something this court needs to get into, because it first needs to look at whether or not the treatment was reasonable and necessary. And the court, the compensation judge, who reviewed all the evidence, he did review Dr. Gorin's opinion, who, after citing medical review articles, in her opinion, found that the use of RFAs and ESIs in this method was not supported by medical literature. So it's not, and not to get into morality, but she did not say it was cruel. She did not want to hurt the employee. She said, based upon medical literature, the frequency of these procedures is not reasonable and necessary. And before getting into the parameters, before analyzing JACA and the rare exception, as the compensation judge is required to do when treatment parameters is raised under case law, he says in finding 62, he adopts in part Dr. Gorin's opinion regarding the reasonableness and necessity of the parameters.
Stop you right.
Yeah.
Standard of review. As you position it, and we all know great legal arguments are made by misstating or overbroad or over narrow interpretations of the position and then arguing from it. I think Judge Sundquist has asked about the decision whereby the Supreme Court has taken it in terms of the premise, the argument, to look at something de novo on the very issue that we're here today. So, yes, I would say standard of review, is it that clear to everyone what the standard should be here? Whether or not it's a de novo or a hanging bill?
Well, even in Darchuk's, I believe the court said reasonableness and necessity is a question of fact. And then when you're looking at treatment parameters and going beyond, there may be a legal question here. And it's our position that you don't even need to do that analysis here, because the judge found in finding 62 and adopted the opinion in part that Dr. Gorin's opinion was the expert he selected in part, and therefore he found treatment was not reasonable and necessary.
So we don't need to get into the analysis of what is temporary or progressive?
I don't think this court needs to address those questions at all. I think the findings in the memorandum speak clearly that the compensation judge found, regardless of the parameters and regardless of the rare case exception, that this treatment was not reasonable, was not necessary, and this court doesn't need to get into that analysis because of that. This court has told compensation judges when treatment parameters and the rare case exception are raised at a hearing, they must analyze them or the case will get remanded back. But that doesn't need to control the issue. And in this case, the treatment itself, getting sometimes 5, 6, 7 ESIs in a year, as well as 2 to 5 RFAs a year, essentially one every other month or one every 0.5 months since 2007. The compensation judge, relying on the medical literature that Dr. Gorin cites and Dr. Gorin's opinion, found that to be excessive and unnecessary and did not fall within 176135 as reasonable medical care.
Shouldn't the judge have considered the more broader based scope of the 4 corners of the box, the lifestyle, the commitment to getting a job, the work activities, to talk about progression? If you have a condition that waxes and wanes, and it doesn't fit into the linear box of which we're listening to today, which the CJ, I believe, found pretty narrowly that temporary is not progression and therefore we're done. And I think they need that to be clear. Then how do we analyze a case where medical treatment is pretty much all that's left besides self-medicating or moving down a path where none of us want to go, to allowing somebody to continue to live and do their activities and to have a life? Because are you back here in a year if you can't work anymore? Are you back here if his life activities are so diminished because he's not getting the treatment, then would you say you're not off the hook for the treatment? 2 years?
Well, Judge, I think that the compensation judge actually did analyze that, and in the findings, he specifically notes that the employee had the effects of his most recent ESI had worn off 3 weeks prior to the hearing. He said his pain was 7 at 10. He said he went hunting, was able to do that. He said he was able to work. And in fact, over the last, I believe, 8 years since he started working, he testified he only called out a couple of times due to back pain. So his test.
Read that more than one way. I could say that's intolerable, and every has tools and measures cannot tolerate. So I move somebody through that has a tolerance level that's higher, but at a certain point, suggesting that you're done because it's not linear.
Well, I think that goes to facts, not evidence. There's no evidence here of lost time. There's no opinions from any contemporaneous doctors saying, but for these ESIs, he would not be able to work, but for these RFAs. You don't have that record in front of you, and neither does the compensation judge. The employee also did not testify to that fact. And so it would say that the compensation judge had to take medical snapshots of an employee at times where there is no evidence, at times he did not testify to, and make an opinion based upon a guess on a record that's not before him. And if anything would be clearly erroneous, it would be a judge reading into the employee's words far beyond what was testified to. But what was testified to was a couple of days. And that even when his pain was 7/10, he has not missed work. And I think if you want to specifically talk about the rare exception, I think, ASTI versus Northwest Airlines is very distinguishable from this case, because there, the treatment was used to return the employee back to their date of injury job. The treatment was limited in scope. It was a single year of a health club membership. There was evaluations by doctors that said doing this kept them stronger, and they were not permanently and totally disabled. Whereas here you have an employee who testified that he works 3 to 5 hours a day, up to 20 hours a week, but you have no records confirming that. You have no evidence that he works only because of this, and you have, most importantly, no analysis that his job duties, sitting and welding, are of the kind that requires him to have these. And so reading in the record that he would not be able to function, would not be able to live, isn't something that's actually in the record. The only testimony he gave regarding his functionality was that he can move a little bit better. It's a little easier for a very limited period of time. And in some cases in the record, it's as little as a week and a half. In some cases, it's up to a month and a half to 2, but he testifies that when he hits back to that baseline, he calls, and it could take 2, 3, 4 weeks to get an opinion. So we don't even know how long these last, but they're not lasting 6 months, a year. This isn't long-lasting treatment. This is short pain relief that the Department of Labor and Industries review board has had multiple chances to review these language. This has been encapsulated in the treatment parameters for a long time. They have decided that this is adequate based upon the treatment employees are receiving, the real world consequences of this treatment and the cost, and have made the public policy decision not to alter this, even when it's come up in cases like COSLAC and the cases where ESIs and RFAs have been looked at by this court. And typically this court has in fact upheld compensation judges' findings that stopping regular patterns is supported by evidence when an expert and the compensation judge have agreed with that expert.
Would you like to comment on the plain meaning of the words? If we go forward, because that analysis seems to be basis bring into the weeds.
Sure, absolutely. And as we cite in our brief, the dictionary definitions are quite clear on the words progressive and improving. You have to show some progress, some upward movement, some improvement. What you have here is up and down, but always down. The employee's testimony and the records in front of you are quite clear. He always goes back to that baseline. He has not improved. And he started work in 2013. There's no indication that he ever improved. There's no indication that he got better. He got more hours. There's no functional improvement. There's no evidence of any difference in symptoms from 2007 to today.
the notion of improvement really, because when I look at progressive, I can have a disease such as ALS, and it's progressively moving forward. It's not linear, and we all know what the result is. It's getting worse. And that's the progression, right?
True.
In certain diseases. Why does it have to, in your mind, be limited to a linear march of improvement as opposed to waxing and waning if you look at the overall picture of the employees?
Well, and
Condition.
I would say because the word improving modifies progressively. And so you would never describe ALS as a progressively improving disease.
No, you wouldn't. You would describe it as progressive.
Correct. But that's why the word improving is there to modify progressively. It says progressively improving in the statute, or in the rule, excuse me. And that is by choice. And that is specific to say you need to have improvement that is going upwards, it doesn't necessarily need to be a linear fashion. Not everyone improves in a linear fashion, but you have to show a difference. And the reason the parameters were written is to show that this medical treatment, the medical treatment, specifically ESIs and RFAs, are in the rules. Most medications are not in the rules. Most modalities are not in the parameters. The department looked and said, this parameter needs to have certain effects, or it's not reasonable and necessary if it doesn't have those effects within 3 injections. They said, okay, but you can depart if those injections are continuing to show an upward mobility. If they're not, this specific modality isn't reasonable and necessary any longer. You shouldn't have it because the costs, the improvement, the usage isn't reasonable and necessary. And, contrary to what appellant said, the employee has been offered other modalities of treatment. He's getting massage. He's on non-narcotic medications. He was recommended for a pain implant. He was recommended for a spinal stimulator. He was recommended for physical therapy. He's declined those and chosen this as his own. And so, are there other modalities out there? The doctors have all said, yes, this is the only way to improve him or change him. He's declined the other options and picked this. And the parameters and the departures are very clear that unless it's actually improving his condition, it doesn't warrant a departure. And so while it may not necessarily seem appropriate if the cost is shifted to the private healthcare system, that's what the workers' compensation statute says is workers' compensation insurance. The employer is no longer required to be the ones paying for it because we've set these limits that have been repeatedly upheld by the Supreme Court as something that limits treatment in the work comp setting.
Mr. Cordes, was Dr. Guerin's opinion ever updated from 6 years ago?
It was not. And, to speculate along with appellant here, I do not believe it would change her opinion because his symptoms didn't change. His responses didn't change. He got off the opioids and he's still getting the RFAs or the ESIs every 2 to 3 months. And so the usage didn't change. The functionality didn't change. And so I don't believe that there's been any medical change in his condition that would warrant or needed a repeat opinion.
Not even the fact that he's taking certain.
No,
It's heavily into it.
I don't believe that would, because his responses to these have not changed. The frequency, the pain levels, he still testified it goes up and comes down at the same rate regardless of the opioid narcotics.
Mr. Cordes, did you find it interesting that Dr. Guerin, in her diagnosis of the employee's condition, did not once mention that he was post-surgical, and did not once mention that he had a fusion surgery or that he had failed back surgery, failed back syndrome, but she did mention that he had a vitamin D deficiency. Did you have any question about, what exactly she was doing here?
I'd have to go back honestly and reread that portion to see, but she does reference his treatment. She did review all those records. She wrote a very extensive report, and most notably, foundation was not objected to.
I understand that.
I think I'm out of time unless.
Sure.
I just have one quick question for you, Mr. Cordes. The heating pad, what happens when the heating pad?
I don't know that I have an answer there. The compensation judge's opinion said medication. Obviously, it's not medication. I think it could probably just needs to be remanded for a quick decision from the judge one way or another as to whether or not it's reasonable or necessary.
Do you really want to remand it for $61 heating pad, or can you go? Is there something that your clients would not be willing to do?
It's quite possible we can talk after this to see what can be done, and if something is, we'll alert the court.
Well, as I would say, it's a lot of cost and time to litigate a heating pad. So we all understand that, and thank you, Judge, for bringing it up, but it will be remanded for the heating pad because everybody agrees it should have been decided and there needs to be a finding more.
Thank you.
Any other questions, judges? Mr. Cordes, thank you.
Thank you.
That concludes the oral argument on this matter. We will issue a decision within 90 days.
Thank you.
Ms. Conner will stay.
I will, Your Honor.
Is next at 11?
What?
I mean, what?
It's at 1 o'clock.
All right, so we can say, so what, Michael, tell me what you want to say.
You can just put the court in recess. That's what they're doing.
Okay, we'll recess for 15 minutes. Thank you, Madam Letter.